May take your lordships. I sometimes I remember a death penalty case where they were arguing before a bench of 3 judges before lunch. They were not convinced that I have a case for computation of death penalty, but after lunch, the bench asked me, we would make it a life imprisonment. What have you got to say? Would you still like to argue the matter? I said, certainly not. And that's how the matter ended. So I was trying to find out if I can respond to some of the questions during lunch and you very clear. But what is constantly coming to one's mind and not underscoring the importance of this matter? Not at all. Certainly not. And I don't think I can do that. What is repeatedly coming to your mind is this: look at the contents of the reports which are placed before the court. Are these reports based on their focus consideration of certain factors which arouse the anxiety and the concern of the government on the immediate and an urgent need for stepping in and changing the current contours to move towards a higher level of confidence for democracy and rule of law? I'm not able to find from the contents of the report that such a consideration has really taken place. I want to show, for instance, the Goswami Committee report the Lordships drew my attention to. A couple of paragraphs in the report, and thereafter to show that the Goswami Committee report has been looked into by the Law Commission and thereafter by the Electoral Reforms Commission. The Goswami Committee recommendation seems to be some kind of a genesis for later day commissions to look into them and either adopt them as it is, and it looks like that. Therefore, that raises one important question: what the court can do. I said, if the reports have certain content, context specific, and it has an evaluative element in them, and the evaluative element, on the basis of that, there is a direction to be taken, then the court may probably pick up those evaluative elements and say, how do we ask you to have a relook at those evaluative elements? But if there's no evaluative elements in those reports, they're simply based on a certain policy consideration of borrowing from some other jurisdiction and things like that, then perhaps the court's journey into that area of asking the executive or the parliament to deal with them, it becomes a little nebulous area. That's where I am repeatedly coming back to it. So let me take your lordship's attention to page 4 to 8, where the Goswami Committee report begins. Para 1.3. 1.2 and 1.3. The massive operation of a countrywide election naturally inspires global awe and respect. Holding of elections in sky-high and snow-clad mountains in north, scattered tiny islands north, thick forests and seas, in vast tracts of marshy so-and-so. At the present reckoning, the electoral ministry has to plan and manage an election for electorate relief 500 million spread over 25 states, 7 union territories, big and medium so-and-so. Then kindly turn to paragraph 1.5. Leaving now our Lawrence alone, becomes imperative to take stock of the present state of affairs, which causes real concern and anxiety because of the existence of the looming danger threatening to cut the very roots of free and fair elections. And what are they? The role of money and muscle powers in elections, deflecting seriously the well-accepted democratic values and ethos and corrupting the process. Rapid criminalization of politics, generally encouraging evils of booth capturing, rigging, violence, etc. Misuse of official ministries, the official media and ministerial increasing menace of participation of non-serious candidates form the core of our electoral problem. Urgent corrective measures are needed, the so-and-so should collapse. Electoral reforms are correctly understood to be a continuous process, but the attempts so far made in the area did not touch even the fringe of the problem. They proved to be abortive. Some of the recent measures like reduction of voting age and anti-defection law are laudable, and the basic principles underlying those measures should be appreciated. But there are other vital and important areas in election feel completely neglected and left high and dry. All these 4 decades, especially so, the demand for electoral reform is mounting up. Subject of electoral reform received wide attention shown for many eminent persons at various occasions, relevant to make reference in brief to some of them. There are about large number of reports from the Prakash Narayan Committee report onwards. Then I may skip this report sequence and page 431 para 1.10. Thus, there are existence, informative, productive, and useful voluminous materials on the subject. The general public has been getting the feeling that lack of political to undertake any useful exercise of electoral reforms. So, if you give a quick glance at any one of those reports and the concerns, which have again been noticed at paragraph 1.6, many of those reports touch on those subjects. And by and large, how do you ensure that a free and fair election by avoiding criminalization of politics, muzzle and money power, so on and so forth, have been the most focal point of electoral reforms. And that's how this committee came to be constituted. And what is generally outlined in page 432 is in the context of the background of this. Therefore, this general outline gives an understanding as to in what way put all of them together and how will we move forward in a direction where free and fair elections will be assured. Now, I didn't find in the rest of the report anywhere which deals exclusively with the question of item number 2 on strengthening the election commission and securing its independence, except what is stated here in para 432 and some broad statements somewhere here and there. I didn't find anything which would really.
437.
I'll come to that. What is stated in 437 again?
436.
It's a recommendations. These are recommendations. But what I am trying to point out is the basis of the recommendations must be somewhere in point of time that I have a survey. This survey tells me that these aberrations, distortions of abuse of power, etc., have entered into the composition of the election commission, which can be probably led or lead to a conclusion that if it is not neutral and independent, there is every possibility of every step in the election process. There are measures in the election process. Every step in the election process which can be subverted. So the idea is that such a body should not be a handmaid of the executive. That's the idea. So therefore, unless it is shown that it has become a handmaid of the executive, for reasons shown like this, and therefore we need to have the recommendation. I'm not again for a minute doubting the wisdom of the recommendation. I'm not on that at all. Because if you're on that, then different considerations will come. So then we need to have material. There will be exchange of views, which is good, which is fair. Why do we look at it? All those issues. We are not able to reach even that point of view. That is where my difficulty arises. We are able to reach that point of view on the wisdom of the recommendation based on a variety of considerations and factors. Then the court probably could enter into all of them. As I said, the evaluative element which is absent in the report. It is just a recommendation, but an evaluative element which must link with saying, yes, here is an evaluation that the long history of appointment process inevitably leads us to a conclusion that there is a danger of the electoral body becoming a handmaid of the executive, and then therefore all that is need to be done by an election body will down the line can be questioned or become questionable. If that evaluative element is not there, then all that I have to come back to my original statement that yes, we still probably can look at it in a different way. These recommendations should be worthy of consideration. They stand on a different footing. So recommendations which are based on survey, evaluation, consideration, and conclusions. A reasoning and a conclusion. If these elements are absent in a report, will it be possible for the court to say I pick up a recommendation part of it, and then I say why government has not applied or leaned in favor of the recommendation would be a very difficult question. So I say so in respect of all the reports. There is a Law Commission report which has picked up this Goswami Commission report. Law Commission report looks at the other examples of other countries. They all picked up and said, yes, I think this is better to be done like that. So even for a lawmaking body or an executive to take a policy decision, it must have before it a concrete set of factors, facts, information, data on the basis of which somebody can apply their mind, analyze, evaluate, and which direction a policy can take. If that assistance is not available within the contents of the report, to simply ask somebody to abide by the report or to make it part of a law, I think somewhere there will be a problem.
You want to say that unless it is being projected, that a neutrality, which is a sine qua non,
Your Lordship, yes,
is being compromised,
yes,
and the instances are coming on record,
right.
then only the recommendations.
That will be the best way
Why
of doing.
why can't we put something with neutrality is not to be compromised,
Yes,
and we can initiate a process so that at no point of time the stage should reach where the neutrality is compromised, and then only we think forward what to be done.
I would.
We don't have a remedial mechanism when we come across and confront with any kind of a injury caused to us.
I understand that.
If we feel that there is a possibility of an injury being caused, better to make changes in our own approach.
Yeah, I quite see that question. Let me try to, because we are now again trying to grapple with various dimensions of a point. I am not shying away from.
No.
I am trying to say which.
We just
I understand.
dialogue each other so that we may find out what is the better mechanism.
Right. And then what I try to say is not saying that, well, look here, don't do this. That's not the way what I'm trying to say.
You see,
In some circumstances.
in this context, it's 436%.
No, there is
No,
the
the recommendation made by the law commission, page 436, is the read over.
Page 437 is the recommendations.
Yes, correct.
Correct. I'm not talking anything about the recommendations at all. If there is something to disagree with the recommendation, that's a matter for debate.
That's correct.
I am not saying anything about the recommendations. I'm only saying if the court were to accept, or even a policy maker were to accept the recommendation, or what will be the basis for proceeding further on the basis of a recommendation. I said something very important is the content of a recommendation, the evaluative content, the inputs in the recommendation. If there is no guidance available, then of course the parliament will say, all right, I'll enact a law, but how do I do it? Why do I do it? Well, these are considerations which more the executive and the parliament will certainly, embark upon. It's not at an abstract level. If anything that we done abstract level, of course, our social order will proceed on a different footing. So therefore, the abstractness of it will certainly not be the guiding principle. So in that context, since I said 1990, the report came thereafter, is virtually a replication of these recommendations. And none of those recommendations, again, I find I'm not able to persuade myself. I was part of the law commission when they gave the report. So there is some part of the recommendation had large-scale consultations. For instance, on the question of criminalization of politics, disqualification of persons who can contest election, we had large-scale consultations across the country. In fact, I authored the concept note and said we should have complete criminalization should be completely, avoided. But no political party, I may share, no political party was at item with us on that question.
They can't be.
So therefore, there is some blockade somewhere. We must overcome it. How do we overcome it? The law commission says, I want to give a recommendation, so the government will be able to consider that. So why I'm trying to say, fall back on this, I think in order, that's why I refer to the UK example. There, a system has been put in position. It goes through a process of consideration. Parliament looks into it. The Parliament then, in an action taken report, comes back to the government. We don't have that system. We don't have that machinery. Therefore, the first point of time, any report before the court can be inclined to call upon the executive to act on the report. Certain criteria must be internally available within the report and intrinsically adding well to the content of the report, which then probably can become a reason for a debate. If within the reports, these criteria are intrinsic qualities which can be persuasive enough to command the executive to move in a particular direction, if they are significantly absent, then will the court say yes, regardless of all those absence of those criteria in a report, for other consideration, namely, we have 75 years, 80 years, whatever consideration, or people at high level, like the Prime Minister has sometimes said, do this. Those considerations would be rather extraneous for the purpose of asking the executive of the parliament to enter into the debate. That's where I've looked into the reports again and again. I find there is this problem. And the question again comes back to me: what is that the court can do? So I have no. It's not a binary question. You can do this, you cannot do this. It's not a binary question. There is, therefore, again, an area where if the attorney were to say, well, these reports do not have those persuasive content, but it is certainly open to the court to ask the government to apply its mind and see where it can go ahead. Beyond that, because even that, I again look further beyond that. Suppose the court were to say, it's a fairly long duration of republic, and this is reports, whatever be their intrinsic content, there is some pointer, some signpost. So why don't you look at it? So then the next step is what will the executive is supposed to do? So they have to apply their mind, and yes, they may accept it, or they may say no, there are other reasons why we cannot accept it. There could be deliberation between the executive or the policy making level. Suppose if the government were to accept it and say this is worthy of acceptance, we enact a law. And then next question is what kind of a law? What procedure? What process? What criteria? What norms? So the court will certainly not enter into all those questions at this point of time. But then if the recommendations have to be really considered and translated into law, can you segregate those aspects, the secondary aspects, but only look at the primary aspects? I think there is some problem. This is one. The third issue is, if these reports have been able to point out that by reason of the lack of perceived, not merely subjective, lack of objectively perceived understanding that there is a live connection between the disability being imposed on a voter not being able to engage in a free and fair electoral process only by reason of the composition or the appointment process of the election commission, then one can understand. I don't think that will ever happen. That connection, I don't think, can ever happen. It will be too remote. It will be too remote for somebody to say the composition of an electoral body, because of the process of appointment, etc., can lead to a compromise on the electoral right to participate in a free and fair election. Our country has not gone into that stage at all. And the whole series of legislations and rules and regulations under the Representation of People Act, and courtesy Vaginder Singh 324 being occupied by guidelines and instructions issued by the Election Commission of India, that question, I think, will not arise at all. So that's why in para 1.3, they're talking about the other important, more important issues. Para 1.6 at page 429. And they have been by and large addressed in good measure or in inadequate measure. They've been addressed. Maybe we still need to go further on the criminalization of politics. And important steps have been taken place, courtesy the intervention by this court on Association of Democratic Reforms, that the right to know is part of the right to free and expression. So these are areas by which, where the actual concrete situations when a free and fair election participation by a candidate or a voter can be enhanced. So it's a question of enhancement, the quality of the process at that level, where the court will definitely come in and say something. But where that is not the real issue. So I think there is, acting on the basis of the reports will be a matter for a serious restraint on the part of the court. Now, the law commission report, law commission state. National Commission. See? On which page? One. And if your lordships come to the 255th Law Commission report, which begins at page 155, if you look at the table of contents,
You are referring
from what I may consider as
which
being
page?
part of the
Which page you are referring?
page at 157. So probably it is in terms of the importance of the issues, and there is, so it begins at regulating election expenditure, A, B, C, D, electoral expenditure, E, legal action and under-reporting of election spending, then state funding of elections. Then comes the third part, the regulation of political parties and inner party democracy. Then Roman number 4, from first past the post to proportional representation. I may stop here for a minute. This first past the post to proportional representation was also a matter considered by the Constitutional Review Commission earlier. Then we come to anti-defection law in para 5. And thereafter, we have this 6, strengthening of the office of the Election Commission of India. If you look at that, so page 261 para philosophy will read anything from para 6.1 to 6.8. It's all a narrative. It's a historical narrative. And then para 6.7, so the focus is on removal of election commissioners, chief election commissioner. Therefore, after that narrative and referring to TN session, there's a recommendation at page 263 in para 6.9. These are recommendations in the context of tenure of office. And this is, of course, post 1991 Act. Then there is para 6.10.1. The Law Commission looks at the constitutional provision. Kindly turn to page 264. And para 6.10.2, the Commission notices that how Article 324(2) was left open for the Parliament to legislate on the issue. In 6.10.3, the Goswami Committee recommended a change to the appointment razor, suggesting the CEC should be appointed by the President in consultation with the Chief Justice of India and the leader of the opposition. In turn, the CEC should be additionally consulted in the question of appointment the other election commissioners should have statutory backing. This was followed by the introduction of the Constitution 77 Bill 1990. It was introduced in the Rajya Sabha, and so providing the CEC should be appointed by the President after consultation with the Chairman of the Rajya Sabha, the Speaker of Lok Sabha, and so and so. The CEC was further made part of the consultative process and appointed the Election Commission. However, and so and so moved a motion to withdraw the bill, which was finally withdrawn to leave the Rajya Sabha on the same day. Consequently, in the absence of any parliamentary law governing the appointment issue, the Election Commission are appointed by the government for the day without pursuing any consultation process. So the Law Commission thinks that a consultation process is important. This practice has been described as requiring the Law Ministry to get the file approved by the Prime Minister. They would then recommend the name to the President, that there is no concept of a collegium and no involvement of the opposition. So again, the perception that opposition must be involved, there must be a consultative process, may be important considerations which may enhance the quality of appointment process, but we're wondering whether they would be matters in the absence of any other evaluative content in the report can be ipso facto worthy of being. The commissioners are appointed for a 6-year period. I'm reading para 6.10.6. Up to age of 65 years, whichever is earlier. No prescribed qualification for appointment, although convention dictates that only senior serving retired civil servant, the rank of a cabinet secretary or secretary to the government of India, an equivalent rank, will be appointed. The Supreme Court rejected the contention he should possess qualifications similar to that of a Supreme Court judge, despite being placed on par with them in terms of the removal process. Therefore, even here, the commission does not find that there is something seriously wrong. Then the comparative practices in other countries is noticed. So 6.11.1, South Africa, then 6.11.2, Ghana, then 6.11.3, Canada, then 6.11.4. In all these cases, thus, it's clear that the appointment of the election committee, electoral office, is a consultative process involving the executive, legislature, or independent bodies. Recommendation. Given the importance of maintaining the neutrality of the ECI and to shield the CEC and election commissioners from executive interference, its imperative becomes a consultative process. And there are certain other observations made here. So kindly turn to para 6.12.2. To this end, Commission adapts the Goswami Committee's proposal with certain modification. Appointment of all the election commissioners should be made by the President in consultation with the three-member collegium or a selection committee considering so-and-so, so-and-so. Commission considers the inclusion of the Prime Minister as important as the current government. Second, the elevation of an election commissioner should be on the basis of seniority, which is what is happening. Election commissioner, with seniority, is then becomes the chief election commissioner. Then such amendments are in consonance with the appointment process in Lokpal and Lokayuktha Act, Right to Information Act, and Central Vigilance Commission Act. In pursuant to Article 324(2), an amendment can be brought to the existing Election Commissioner Act 1991 to amend the title and insert a new chapter on the Election Commission CEC as follows. So this is how the proposed suggestions are made. And appointment is chapter 1A, chapter 2A. We say the recommendations of a committee consisting of so and so, so and so. Then I'm not turning my attention to the independent secretariat, etc. They are essentially matters that can be dealt with on a different level. So this is how the recommendation of the Law Commission has been made. So 3 or 4 factors which emerge from here. One is the other examples for the other countries. Then the consultative process, which is probably available in the in certain other statutes. And I pick up from the Goswami Committee report, consultative process very important. So where do we go from then on? If the court were to say, this is the recommendation of the Law Commission, and if the court were then to disregard my submission that there is no evaluative content, there is something is there, but not fully to a satisfaction, regardless of that, the consultative process is something very important for the enhancing the quality of the appointment process. Therefore, it appeals to us, it commends to us that the consultative process will be taken into consideration by the executive before the appointment process is made. The court may then look at it. But before the even court looks at that, I come back to my other difficulty. This consultative process will have to be then put into the form of a law. There is a 1991 Act. The Law Commission says, have your 1991 Act amended so the consultative process can come in. So it ultimately means this law has to be amended. So the amendment of a law, we come back to our first point of time. Therefore, how do we really break ice? Is there a way of breaking the ice? So I started saying I may not be seen as saying that in all these important matters, the court's engagement on policy formulations will always be eschewed. I'm not saying that at all. But I'm only trying to point out that there are several what called intermediate matters and issues which are matters of concern.
The right to vote, is it a statutory right? Is it a constitutional right? What is your? Is it a statutory right? Is it a fundamental right? Is it a constitutional right? the right to vote as such. The matter is no longer res integra. The matter has been settled by this court. There was a division of opinion. While it is referred to as three judges bench, it was answered in 2013, 10 SEC page 1, popularly known as a Nota case. So kindly turn to that because we have to go by that process. 2013, volume 10 SEC, it is not part of the common compilation.
I just give it.
Yes.
2013, volume 10 SEC, page 1. For that, we could possibly go through that the earlier judgment in the democratic reforms case, that is 2002-5.
Which paragraph?
Paragraph 28.
20.
Because the question arose whether the petition under 32 is maintainable. Answering that, and with reference to the earlier two judgments in Kuldeep Naik's case also, the court proceeds to hold it is a statutory right. But then there is a facet of it which, because the freedom of expression, to know about the antecedents of the candidate without information being made available in a democracy, rights cannot be exercised.
Absolutely. There can't be any disagreement.
So there, the court said, if you just see para 28,
Para 28. 20.
you can read from para 26 because it deals with whether the petition is maintainable.
26.
Or rather, you can perhaps, you can read from
In the earlier part of a judge.
21.
21.
Para 21 onwards, you'll get the entire discussion.
Yeah, three-judge bench of this court comprising.
Have you got, my brothers got this? No, have you got this?
I'm so sorry. We'll have it. I'll hand it over.
This is not part of the compilation. Not part of the compilation.
I'll just take it.
You can read para 21.
Just give me a few minutes. May I read para 21? A three-judge bench of this court comprising so-and-so, separate but concurring opinions made observation as to the right to vote being a constitutional right, if not a fundamental right which reads under. In Jyoti Basu, this court again pointed out in no uncertain terms. The right to elect, a fundamental though it is a democracy, is anomalously enough neither a fundamental right nor a common law right. It is pure and simple a statutory right. With great reverence to the eminent judges, I would like to clarify the right to vote, if not a fundamental right, is certainly a constitutional right. I stop here for a minute.
Please read on. I mean, after we'll not yet over because it's a beginning of a.
This right, the right originates from the Constitution and in accordance with the constitutional mandate contained in Article 326. The right has been shaped by the statute, namely the Representation of People Act. That, my understanding, is the correct legal position as regards the nature of the right to vote in election to the House of the People and the Legislative Assembly. It's not very accurate to describe it as a statutory right, pure and simple. Even with this clarification, the argument is Learned Solicitor General. The right to vote not being a fundamental, the information which at best facilitates meaningful exercise of the right cannot be read as an integral part of any fundamental right remains to be squarely met. Similarly, so the right to vote, the election to how the people legislative assembly is a constitutional right, but not merely a statutory right. Freedom of voting is distinct from right to vote, the facet of the fundamental right enshrined in Article 19(1)(a). The casting a vote in favor of one or the other candidate marked the accomplishment of freedom of expression of the voter. And that's the issue in this case. Except the above two paragraphs, the aspect has nowhere been discussed or elaborated wherein all the three judges in the separate but concurring judgments have taken the pain to specifically distinguish between the right to vote and freedom of voting as a species of freedom of expression. In succinct, the ratio of the judgment, whether though the right to vote is a statutory right, but the decision taken by a voter after verifying the credentials of the candidate either to vote or not is his right of expression in Article 19(1) of the Constitution. As a result, the judgments in Association for Democratic Reforms and PUCL have not disturbed the position that a right to vote is a statutory right. Both the judgments only added the right to know the background of a candidate is a fundamental right for a voter so that he can take a rational decision of expressing himself while exercising the statutory right to vote. In PUCL, how the voter's fundamental right to know the antecedents of a candidate is independent of statutory rights. Under the election law, the voter is the first citizen of the country and apart from statutory rights, is having fundamental right conferred by the Constitution. And Venkatram Reddy said, so the initial right cannot be placed on the pedestal of a fundamental right, but the stage when the voter goes to the polling booth and casts his vote, his freedom of expression arises. The casting a vote in favor of one or the other candidate tantamount to expression of opinion and preference. At that final stage in the exercise, the voting right marks the accomplishment of freedom of expression of the voter. That's where Article 19(1)(a) is attractive. Freedom of voting and the distinction of the right to vote is a species of freedom of expression and therefore carries with it the auxiliary and complementary rights such as the right to secure information about the candidates which are conducive to the freedom. In para 25, after careful perusal of the
come to the middle of the next page because we can save time. Page 19, towards the middle of that para,
this page,
the court goes on to say, thus there is no contradiction as to the fact that the right to vote is neither a fundamental right.
Yeah, thus there is no contradiction as to the fact.
But
as to the fact that the right to vote is neither a fundamental right nor a constitutional right, but a pure and simple statutory right. The same has been settled in a catena of cases and clearly not an issue dispute. With the above observation, we hold that there is no doubt or confusion assessing the Constitution by judgment in Kuldeep Nair and do not stand impliedly overruled.
Now you come to para 28.
The decision taken by a voter after verifying the credentials of the candidate either to vote or not is a form of expression in the Article 19(1) of the Constitution. The fundamental right in the Article 19(1) read with the statutory right in Section 79 is violated unreasonably if right not to vote effectively is denied and secrecy is breached. This is how Article 14 and 19 are required to be read for deciding the issue raised in the petition. The casting of the vote is a facet of the right of expression of an individual, and the said right is provided in Article 19(1)(a). Therefore, any violation of the said right gives the aggrieved person the right to oppose this court in Article 32. In view of the aforesaid decisions as to the observation of the Constitution bill, a prima facie case exists for the exercise jurisdiction of this court under Article 32.
So we have a quaint sort of mix of principles. The right to vote per se is a statutory right. But certain aspects, facets of that right, they are part of the fundamental right under Article 19(1). For example, I have a right to vote, but I have a right to receive information, be fully informed about how I go about exercising that right. I have a right to say that I will not vote for anybody and say press a nota button.
Correct.
So the fundamental rights are actually read into the statutory right. So why we have made this effort is to bring home the fact that we may have to proceed on the footing that the right to vote simpliciter is a statutory right. So the three judges unless they are able to show something else. No, but then your woes are not an end because of that. Because the fundamental right is again read into, as we have pointed out to you, paragraph 28, the facet of how you express yourself, it's part of the right inherent in every citizen. There is a part of the fundamental right in the right to vote, in other words.
I concede.
So your objection to not, making use of Vishaga in the region of Article 324 may not be fully right, except to the extent that the right to vote per se is not a fundamental right. Second thing is the reservoir of power, which is actually, with the Election Commission of India is so wide. That's what the court keeps on saying. If you see the association judgment, court has used Vishaga in 324. But that was for the purpose of the statutory power. That association case, 2002, 5 SCC 294, Vishaga is used in para 34 to 37. Whether it could be done. But that is again, you're right there, that is again in a statutory context, not in a constitution provision.
I right. Your Lordship.
But the fact remains that there is a fundamental right.
I'll try to find where one can have a little more dialogue.
Yes.
I'm thankful to Your Lordship for it.
Yes.
Lords, if I may,
Yes.
just for a minute, because your lordships are on this issue.
Huh.
One judgment 2016, 2 SEC 445,
Huh.
which is of Justice Chalameshwar and Justice Sapre, Rajbala versus State of Haryana.
Panchayat election.
Yes, the Panchayat
The
elections matter. From para 16 to 38, very detailed discussion on this, on the right to vote and the right to be elected, both. And there are many new judgments that they look at, but I must say that this judgment is not looked at. PUCL is not looked at. 3 judges, which they would have had to consider. But they consider the earlier PUCL 5 judges, which said it's a constitutional right.
2016.
2016, even though it was
Salvation.
2 SCC 445.
Education codification for the.
Yes, but those paragraphs actually extract each of the paras of all the previous judgments and come to the conclusion of why it is a constitutional.
But without referring to
This is omitted. They have considered earlier 5 judges, but not these 3 judges.
This is not considered that, yes.
But that is a 2 judges bench.
Yes. But Rajpal has been followed in Puttaswamy also. But again, one of the judges, not all.
That's right. But we have the freedom to take.
Of course, but I'm saying the interpretation.
We are not bound
No,
by the
you're
2
not.
or the 3.
Your lordships are not.
They are not.
But I'm saying the interpretation the principles that they have enunciated and the sequence have gone through, I think that's very helpful.
Yes.
And these two judgments is laid on a constitutional bench list.
Yes, it followed relied PUCL constitution bench. That other Krishnamurti, they said that no, Krishnamurti didn't consider PUCL. PUCL clearly said that it's constitutional. Whereas 18 to 32.
Yeah.
Thanks, my lord. Our case is not merely based on the fact that right to vote, and which is a fundamental right, etc. Our case is based on a larger principle of democracy being part of the basic structure of the constitution, and free and fair elections being part of the basic structure of our constitution. And therefore, it is necessary that the election commission, which is in charge of elections and democracy, must be an independent body. That's
Because, the juridical premise for Visakha is there were a lot of international covenants entered into, and women had fundamental rights, and Parliament was not responding promptly, and matters were being dragging on. So they said, read with Article 142 and the power under 32, which is for fundamental rights. They said there is a fundamental right with the woman.
In fact,
That's how it is recent. That's
Absolutely.
what we have to deal
in
with.
fact, if your lordship sees, prior to Vishaka, in gramophone, your lordship said there's a void on copyright law, so the Berne Convention's provisions were read in. In Vellore Citizens Forum, on environmental law, you said there's a void, so you read in the provisions of the Rio Convention, etc. You did this repeatedly, my lord. In Lakshmikant Pandey, there was void. Vishaka followed that sequence.
That, the matter of international covenants.
Yes.
That's a slightly different.
That's a slightly different thing.
Slightly
But
different
the
area.
question is, when there is a vacuum, your
You
lordship
can read it in the case of the
Correct.
international covenant.
and the rights which are being agitated, which is why your lordship will look at this point, because in
We are just
Vishaka,
being clear, because
Yes.
it is a right to vote per se.
correct,
We cannot ignore the fact that it is a statutory right.
correct,
For example, supposing you say there is a fundamental right.
correct,
At what age do you exercise your right? If I'm a citizen, I am born.
yes,
Okay, I'm 1 year old.
yes.
Can a 1 year old walk into the booth and say, please allow me to cast my vote?
But
I
that's
must
regulated
first of
by
all-
326 in its
Exactly.
own words, when it
That's
says
it.
adult suffrage.
Therefore, I should be 18 years.
Yes,
Correct.
yes,
Then I should various disqualifications, qualifications. They're all prescribed in the statute. So they
Correct.
give the right.
correct.
The
That's
Constitution does not
No,
clothe
it
any
doesn't.
person with the right to vote.
which is why, my lords, those who are in prison don't have the right to vote.
Exactly.
Which is-
Exactly. So therefore it is a statutory right. Aspects of it, that statutory right
Absolutely.
are part of covered by 1920.
Correct, correct. And those rights, when they're being agitated by us, when we find a vacuum, your lordships will do what is necessary. If an international convention,
That is a question.
that's
A question how you go about it. See,
Absolutely.
What the Attorney General is addressing us is a concern
yes,
that bearing in mind the broad separation of powers. We don't
Correct.
have the separation of powers as we have in the United States,
yes,
but we have over a period of time evolved the principle of separation of powers
yes,
in a partial way.
yes.
Because if there is separation of powers, you wouldn't be having 356.
Absolutely.
That is one example where
Yes.
in the earlier judgment of 62 Supreme Court, they say, no, it's not a case of pure separation of powers, partial level.
Yes.
We should not, overreach our boundaries.
No,
And
absolutely.
we say that that's the only concern. We should carefully address that.
Okay.
Otherwise, he has pointed out number of statutes, number of provisions in the Constitution where they say subject to law may be made.
We'll show you how those are distinguished.
They are distinguished.
And there
That's a
are
different thing.
categories into which they fall.
No, what you're saying is the restraint should be there. When we
Yes.
say that we should not jump at the idea and say, okay, here we are.
Even I,
Vishaka,
In fact, since your lordships are looking at it right now, just see. There are only 4 provisions in the entire list that the AG gave you, which says specifically with reference to an appointment subject to the provision of law. Which are those 4?
they can be
324, I'm just telling your lordships, 324, 338, 338A and 338B, which were recently introduced. Because the Commission for Backward Classes, SC, STs, etc.
We say that point.
Your Lordship, we see
that we can.
So that those stand separately.
What you're really saying that when we are this is a 5-judge
Correct, correct.
and not easily
No,
we have to
absolutely,
have a 7-judge dispute
Absolutely.
if we go wrong.
absolutely.
We have a
can
great
settle these.
duty to be very right,
Yes.
to be correct.
Correct.
It's not that we write something
Correct.
and then it has to be reconsidered after 2 months. You have to be careful. That's all.
No,
that
but
is it.
equally
Whatever we do,
important-
whichever way decide.
Well, it's equally important is that we have an opportunity to settle peripheral issues which have agitated this court in a series of judgments.
That's absolutely.
So if
No,
the
don't
right to
forget-
vote being a constitutional right, your lordship will settle it.
Besides, my lord, we are asking for something which was similar to what was asked and done in Prakash Singh or Vineet Narayan. There were no international covenants. The
No.
court proceeded that because the police needs to be somewhat independent from the executive. Otherwise, it destroys the rule of law and it threatens Article 21 rights of citizens. Therefore, and they said that several commissions have gone into this and they have proposed various reforms to do this.
Correct.
Government has not done it. Therefore, now we are going to order it till such a law is made. Same thing we are asking in this.
So there is another thing.
One
I'm
short
just
point I may
taking
make.
up from where Mr. Bhushan left it. See, Article 14 perhaps we have a role to play because the state parliament is also an organ of the state. Obviously, it's making laws. It throws up the very peculiar position where the refusal by parliament to act. And that brings up your question as to whether you can injunct parliament by a mandatory injunction or a mandamus. Please make a law. We cannot do that. But then that leaves us with the question as to whether your inaction can be treated as arbitrary in the peculiar set of facts in the conditions obtaining in our country. And we gave you in 8 years,
Yes.
9, 8.
I follow.
So it is basically, it's all, you can't be running to England, to US, and then borrow everything lock, stock, and barrel and, plant it here because as somebody said, it'll become poisonous.
Very
You
true.
plant every idea, without bearing in mind what happened, what kind of people we are. What is the character we have? Whether we have any left? Where have we reached? What are we doing? It's common sense. Ultimately, law is common sense. You can argue and argue and argue. Finally, what do we get on the ground? Do we get somebody with, say, less than a year on a perennial basis? So it's a mockery. If it is a mockery, what are we doing? What can we do? This is what we are seeing. Yes.
One short point I may make, Lord, in addition.
Alisha, let the attorney complete. Otherwise, it will not go on. Yes.
In apropos what your lordships were putting to me in the other judgment, in the Rajbala judgment, and after stating the proposition and raising the concern in paragraph 28, in that judgment, court goes on to consider how it is important for the freedom of expression. So now it is no longer at the stage of a mere right to vote, but when you go to vote, what do you do? So it's a different, arena altogether. And it's occupied by a fundamental, right? That's what the court has said. I think that's important. I think you did not even have a debate on that. And then in Rajbala, even if it is not considered, the question was whether you were disqualified. Even if a right to a freedom of expression in 1918, that may have no basis or connection as far as disqualification is concerned. The state may have several considerations why somebody may not contest election at all.
Then you just bear in mind that this is not an ordinary statutory right. There are
the right to contest.
It is a right which is, very intimately interconnected with fundamental rights.
Correct.
And what is more, it is most important aspect is it is very integral part of the basic feature which is democracy. That's why we told you at the very beginning. You have to have a premise which is not simplistic, as you very correctly point out. There is no simplistic formula here. It has to be premised very carefully. Otherwise, what will happen in future generation of judges?
Lordships are right. So I'm trying to imagine a triangle. Now we have basic structure on the one hand, then the constitutional right, then a statutory dimension of a right, things like that. You try to look at them. They have intimate connections. They may have some connection somewhere, but because they are connected, will there be a further debate on I have a right freedom of expression 19(1)(a), and that perhaps can be subject to any restriction or an impediment by reason of electoral process. An electoral process which impedes that, one can understand that. But we're not an electoral process impeding that fundamental right.
Not that.
Ah.
See, the point is the position of the Chief Election Commissioner and the Election Commission.
Right.
The word superintendents, the three magical words in Article 324, have been found to contain
Yes.
a limitless reservoir of power, responsibilities, duties, and those duties are shouldered by the fragile shoulders of three men, flesh and blood. They are there. They will actually, be the sort of fountainhead on which the rest of the army of, the officers, their staff, they will decide. You have a session once in a while. I can just recall, in an interview, he says that he was a cabinet secretary. So somebody said that, the Prime Minister has said he wants an election to be declared on a particular day. So he said, I can't go and tell the Election Commission to declare the election on a particular day. That is a call to be taken by the Election Commission. I respect his independence. I'll never go.
Correct.
And he would not entertain anyone who would go to him. So that kind of a man we want, not the political party. Let it be any political party. None of us are concerned with any political party. Let it be any political party. What is important is we put eternally, immutably a system in place. We already have done fairly well under some of these election commissioners. We have put in place fairly good procedures which are also equally important. But the choosing of that man, at least last 20 years, we have pointed it out to you with examples.
I'm trying to get back on that.
Yes. So this is a very, very, what Dr. Ambedkar said, it is going to be the biggest headache. The extraordinary powers of prescience. He knew where we are headed. And we have reached there. Because he takes, see, the point is, there are any number of, any number of situations where the independence, the character of the man is what is most important. Competence is there. Is he competent? But the man has to stand up that I will not allow anybody to bulldoze me. I will take an independent decision, impartial to all political parties. I will apply the rule to everyone equally. If the Prime Minister, whoever in the ministry maybe who tries to, influence me, I don't care two hoots about it. So we need such men. So the point is only this: who will appoint such people? Because the most important person is the man. But how do you get to that man?
Yes.
You have to have somebody who will appoint him. So that is why
I see the connection. I see the connection.
That is
there's a logic. I don't think we can have any digression on that question.
So one more small, I will just, because otherwise it will go on. The point is, the least intrusive of all these models appears to be that the Chief Justice of India is a party, like in the case of a CBI director or whatever. Lokpal also. The Chief Justice, the very presence of the Chief Justice. An independent Chief Justice comes there and he says, the very presence will be sort of the message that you can't be playing, games with, the appointment. You will not allow it. You'll need to pick up the best man. Very simple. Pick up the honest, best man, character, man of independence. See, they have to, in some other countries, they have to file affidavits that they don't have any political affiliation. They were never associated with any political party. At least to the extent that our human institutions can endeavor and produce the best. We should try to do that. I don't think as Attorney General you would oppose that.
No, I don't think to have best people in all institutions.
Absolutely.
I don't think anybody should have any objection.
Exactly.
I don't think even the government should have any objection.
Exactly.
It enhances the quality of governance.
Absolutely. Future generations will look back.
But
to this moment where, you know, this expression of yours will go a long way.
I had only one thing.
Your Lordship.
We all are on, at least on one question, we are all common.
Your Lordship.
That we must select the best. Now, how to select the best, that is the question. And where to find out. And whom we should trust. Either a committee, some mechanism, fair committee, fair mechanism, transparent mechanism. Everyone is facing this
Hello.
problem.
Your Lordship. Your Lordship.
Just to broaden that aspect, see, in Pakistan, our neighboring country, got independence the same time, 1956. They have a system where it's a multi-member chief commissioner, as they call it, and election commissioner. If you see that, you know what I've given.
Yes, sir.
They have provided that the other commissioners should be retired High Court judges. See, retired High Court judges, we know that subject to, as my learned friend said, who selects and who is selected. Generally, we can expect a level of sort of proficiency, competence in that particular field, where they will bring to bear on this huge responsibility, the experience, their independence, their training as judges. What is it that we are actually, we are all with prejudices, all of us have prejudices, but it is all hemmed in by the training. What we are told, you know, okay, you decide according to a particular rule. You don't decide according to that rule. Don't look at the face of the man. The same principle will apply. So here what is happening is, for the last 40, 70 years, mostly bureaucrats.
I'm trying to find
Whether
out.
Roy, we just wanted to point out to you, there has been one woman chief election commissioner, Rama Devi, for a very short period of 70.
I think that's some systemic fault elsewhere.
So if you want to select the best, the selectors must also belong to that class, the best. Otherwise, what would be the problem?
I don't think any party to this debate, including the government, will have a disagreement on that question. I don't think I'm raising that issue at all. The best person to be part in charge of the affairs of any institution is the highest guarantee that the institution will function and then be able to realize the purposes of the institution. And there's no difficulty at all. But I was only trying to find out how we actually look at it in the context of this case. You can say, well, your Lordship may reject my submission that there is no connection between the perceived independence of the election body and the actual right to vote or a right to participate, because there doesn't seem to be a concrete situation where this has impeded the right to vote or the right to express. So therefore, that submission may or may not be rejected. It can be even accepted. But the court were to go further, yes, I don't see a connection between an independent election body not being in position, and therefore there is a shadow is cast on the freedom of exercise of, voting, etc. And then, of course, position will be different. But if you look at certain other broader pictures, like, well, it is not a fundamental rights question because no fundamental rights violations are made out or not even involved, and you can't even perceive it. So the question is there a basic structure question? An independent election body, etc. Then we enter into a different level of a debate. So when every constitution, that's why in Indira Narayan case, they said, look here, this is a slippery slope. How do you add? We've added, brick after brick into the basic structure, only for the purpose of enhancing again the intrinsic strength of the constitution and its being alive. But when you want to have a debate on the basic structure, then we go on a different level. So then it was shown that it affects the basic structure. There must be a law or must be an action which affects the basic structure. So basic structure is always a question where there is an exercise or an attempt to invade the basic structure or affect it. Then only we enter into that question. A mere silence, that's why I said in this case what the court is being asked to do is perceive there is a vacuum or a gap because Parliament has not enacted so far on the subject, and then we look into the vacuum or the gap and said what others have said about it. Now I will try to look at the gap at the vacuum, and therefore, if that vacuum or a gap, take it to the next level. I say it affects the basic structure. Then we are entering into some, circuitous process. That's why I said if the original provision of the Constitution affects the basic structure. So there is some difficulty in entering into those areas. And both Vineet Narayan and Vishaka. No, from the company. Vineet Narayan is there. Give me Vineet Narayan. Vineet Narayan? It is not in the compilation.
The Wikipedia is very formidable. You set up not what fell from my mouth.
It is not in their compilation. Wait.
One is 1998.
That you wanted
I
to.
can pick up Vineet Narayan.
Excuse me. This
Paragraph 3 at page 234. Just above that, in para 2,
Yeah.
just about placitum F so and so, we must also record our appreciation of the office of the CBI in the Revenue Department, who actively participated in this proceeding and showed a definite improvement in their perception of the rule of law as the case progressed, and their ability to perform improved once they were assured of protection in the honest discharge of their duties. This experience revealed to us the need for the insulation of these agencies from any extraneous influence to ensure the continuance of the good work they have commenced. It is this need which has impelled us to examine the structure of the agencies and to consider the necessary steps which would provide permanent insulation to the agencies against extraneous influences to enable them to discharge their duties in the manner required for proper implementation of the rule of law. To focus on extraneous influences. And then permanent measures are necessary to avoid the need of every matter being brought to the court by taking ad hoc measures to achieve the desired results. This is the occasion for deal with the structure, constitution, and the permanent measures necessary for having a fair and impartial agency. The faith and commitment we all concerned in this proceeding is the surest guarantee the survival of democracy with the rule of law is the bedrock. In the next paragraph. 4. Brief narration of the facts is case necessary and so alleged to be an official of a terrorist organization arrested in Delhi consequent upon his interrogation. Raids were conducted by the Central Bureau of Investigation, brothers, relatives. Along the Indian foreign currency, CBI seized 2 diaries and notebooks. The premises they contain detailed accounts of vast payments made to persons identified. Initials correspond to initials of various high-ranking politicians, in power and out of power, and the high-ranking bureaucrats. Nothing having been done in the matter of investigating the Jains and the contents of the juries, the present writ petitions are filed in the public interest under Article 32 of the Constitution of India. And the gist of allegations are said in paragraph 5. Kindly turn to paragraph 8. In para 7, they are talking about the political personalities investigated in the Jain diaries. Then we have taken the view, given the political personalities, it was advantageous not to hear the matter through an issue writ of mandamus, leaving it to the authorities to comply with it, but to keep the matter pending while the investigations are being carried on, ensuring it was done by monitoring them from time to time and issuing orders on behalf. They are referring to a large number of orders. Then para 8, summons substance to these orders, the CBI and other governmental agencies had not carried out their public duty to investigate the offences disclosed. That none stands above the law, so that an alleged offence by him is not required to be investigated. That would monitor the investigations in the sense that you do that permissibly. What we permissibly could do to see that the investigation, the progress, while yet ensuring that we did not direct or channel the investigation or in any other manner prejudice the right of those who might be accused or to stand trial. Made it clear the task of monitoring court would end the moment the charge sheet is filed and all that. Then comes paragraph 9. Even after this matter was brought to the court complaining of the inertia of CBI and other agencies to investigate into the offences because of the alleged involvement of several persons holding offices, for quite some time the disinclination of the agencies to proceed with the investigation was apparent. The accusation, if true, revealed an nexus between high-ranking politicians and bureaucrats and who are alleged to have been funded by a source linked to the source funding the terrorists. In view of the finding also, the foreign currency, some undesirable foreign elements appear to be connected. This revealed a grave situation, posing a serious threat even to the unity and integration. The serious threat for the Indian polity could not be understood. The obvious need for an expeditious and thorough probe, which already been delayed several years, could not be counted. That is how the court proceeded to put its in a hand further in this matter. Then paragraph paragraph 15, they note at page 243, inertia, the common rule whenever the alleged offender is a powerful person, necessary to take measures to ensure permanency in the remedial effect to prevent reversion to inertia of the agencies in such matter. That is one of the anxiety. And paragraph 17. As a result of the debate in these proceedings and the experience gained thereby, the Union of India came to realize that an in-depth study of the selection of personnel of these agencies, particularly the CBI and the Enforcement Directorate, the Revenue Department, their functioning is necessary. Government of India, sharing this perception by an audit its own, so constituted a committee headed by the Home Secretary to take stock of all available information about the activities of crime syndicates, mafia organization, developed links and so on, etc. Then at Placitum C, the committee was headed by the Home Secretary Vora and members so and so, so and so. Then recommendations dated 5/10/1993. It has made scathing comments that has painted a dismal picture of the existing scheme. It says the network of the mafia is virtually running a parallel government pushing the state apparent irrelevance. Committee recommended the creation of a nodal agency, Ministry of Home Affairs, for the collection. I proceed to read it. So we have this committee, and then thereafter, you've got to find that Placitum D. The report of the Vora Committee's opinion, some soft bureaucrats confirmed our worst suspicions, focusing on need to improving the procedure for constitutional monitoring of functioning. In paragraph 18, the same perception of the Government of India led it to constitute another committee by order dated so and so, and called the Independent Review Committee. The order reads as follows. Then the remit to the committee is at page 245. At the terms of the reference, particularly the subpara 2, examine the present structure and working of the Central Bureau of Investigation, Enforcement Directorate, and related agencies, suggest measures, if needed, to ensure so and so any person, particularly those in by authority, are registered, investigated, prosecuted fairly expeditiously and without inter alia against external pressure, ensuring adequate protection to the functionaries. Then B, there are sufficient checks and balances to ensure that the powers of investigation and prosecution are not misused. And C, no arbitrary restriction on the initiation of the investigation. law and
Mr. Attorney,
Then comes,
why this court step in this matter?
no, I want
Why
to,
this court step in this matter?
uh,
The reason forthcoming was,
yes,
at a given point of time, there are a good number of politicians who are under the arena of investigation. Maybe some cases. CBI was the agency who had to investigate. This court felt, and we also know the ground realities. The court wanted that CBI must independently investigate all matters, regardless of the fact who politician and who may be. The procedure for appointment of director was still there. It's not that it was not there earlier. And only after this court step in, the mechanism has come forward for appointment of a director. But the court felt no, that mechanism may not be fair in dealing with the nature of matters which are coming up for the CBI to investigate. Let us put in place an independent agency in making an appointment to hold the post so that an independent investigation, even in the cases of politicians who are coming forward at a particular point of time, they also have fair nature of investigation. That's why this court step in. Otherwise, minus Vineet Nadan, as there was no provision how to the director of CBI to be appointed. There was a provision.
yeah.
And appointments were made.
Yes.
Nobody questioned it. This court also never stepped in.
Let me read how the case progressed thereafter.
The initial paragraph itself.
Yes, right.
This court has disclosed why we are stepping in.
Let me try to pick out a leaf from this
Para
case.
7 or 8, I think.
I'll just come. Para 26, I'll just come to that. The need for insulation of these agencies
Yes.
from extraneous factors which may deflect the fairness of investigation and therefore entirely compromising the investigation process.
Correct.
Regardless of whoever they are who are in deflecting the investigation process, if that's going to actually reflect, the court says,
how to insulate this post of a chief election
I'll
commissioner.
just point out what happened in this case. Little further. I find from the report that they appointed an independent review committee. The independent review committee came with a set of recommendations. And the recommendation of the independent review committee has been accepted by the court. Virtually, whatever were the recommendation of the independent review committee has been simply endorsed by the court. The court has not independently taken an analysis of the recommendation, entered into their evaluation, and the need for ABCD to be accepted, EFG not to be accepted. No. The entire set of recommendations, which emanated from the experience of those who were in the committee, being party to the civil service. They've been there for long. So therefore, this is a case where those recommendations, without any further elucidation or evaluation, the court simply said this can be accepted. Kindly turn to paragraph 25 at page 249, and thereafter.
What do you suggest? In this matter also, we should constitute a committee to provide us inputs for taking a final decision in the matter.
No, I'm not suggesting. I'm only saying that look at the facts of that case. I'm not saying there can be a circumstance when there is no committee at all. I'm just in the abstract. Suppose there's no committee, there's no inputs, but a violation of fundamental right is brought to the notice of the court. Then what is it the court will do? The court will ask for inputs in order that this is how the violation of fundamental right takes place. And those inputs will be essential inputs for comprehending how to avoid a violation, how to avoid a breach of a fundamental right. Then the court will be in a better position to go into that exercise. So therefore, I said this is a case where there was a set of recommendations which was simply accepted by the court. There's no evaluative criteria. There's no further consideration.
What also considered at the subcaption the captain to page number 255, the need for court's intervention. Here also that is very relevant. The need for court's intervention. Whether that is there or not. That is the first question. At page 255.
Page 255.
Then the power of the court, that was also another subheading. The power of the Supreme Court. So these aspects were considered.
Correct. Absolutely.
So here also we will have to consider the need for court's intervention, whether that is required, and then the question, the power, to what extent.
Absolutely, because that's why on the facts of that case, if the government itself felt there is a need for looking into it and gave a set of recommendations, the importance of it is being underlined by the court. There's an emphasis given by the court to say, yes, we see the importance. If the court has not intervened, what would have happened is anybody's guess. Whereas the IRC recommendation would have remained, but the IRC came in the course of all the deliberations. It happened like that. So in the course of the deliberation, there is something available before the court. So that makes it again a concrete situation when the court is in a position to enter into even a minimal evaluation or a minimal consideration. Therefore, Vineet Narayan stands in a slightly different footing. And I say the need for court intervention, before we say that, in paragraph 25 at page 249 onwards.
In this case also that should be considered, the need for intervention.
No, I'm not anyway disputing on the need for intervention. I don't think anybody would have said that. What I'm saying is on a slightly different dimension. Page 249 to 255 are the set of recommendations which the IRC has placed before the court. Those set of recommendations you'll also still find after 255. At page just about the need for just above paragraph 26. The reference to paragraph says so and so, containing discussion pertaining to the Central Bureau of Investigation, Central Vigilance Commission, Directorate of Enforcement in Part 2, recommendation therefore to be read along with discussion in the corresponding paragraph. Then in paragraph 26, immediately after Placitum E, when the report of the IRC is set out, just above Placitum F, there can thus be no doubt that there is a need for the exercise you are called upon to perform. And this is occasion consideration of crucial issue with this court to exercise powers conferred by the Constitution of India. The conclusions reached by the IRC and the recommendation it has made for improving the functioning and thereby the image of the agencies is a further reaffirmation of the general belief. No doubt that the conclusion reached by the IRC and recommendations are the minimum which require immediate acceptance and implementation of it to any further delay of the polity. Exercise to be performed by the court is really to consider any notifications required to make the recommendation of the IRC for achieving the object for the central government itself constitute IRC. We informed by the Attorney General for the action report IRC could not be taken so far because of certain practical difficulties faced by the central government. But there's no negative reaction to the report given by the central government. So that is why the court proceeded to, yes, we give our imprimaturs. In paragraph 48, in view of the page 264, in view of the common perception shared by everyone, including the Government of India and the Independent Review Committee, the need for insulation of CBI for extraneous influence of any kind, it is imperative that some action is urgently taken to prevent the continuance of the situation, with the view to ensure proper implementation of the rule of law. Therefore, here is a common perception which was the basis for the court to proceed further. Then turning over to paragraph 53 at page 266. On this basis, we now proceed to give the directions enumerated hereafter for rigid compliance will sustain the legislature steps in to substitute them by proper legislation. These directions in Article so and so implement the rule of law wherein the concept of equality is embedded as the force of law under Article 141, so and so, etc. Judicial territory of India to act needed to the court. Then 54, before that, we have accepted and are reiterating as far as possible the recommendations made by the IRs. And the standards in public life, then come to paragraph 58 at page 269. So these recommendations you all look at paragraph 58 are virtually a verbatim reproduction of the ARC recommendations.
Yeah.
And why did the court ultimately say I have this 32 read with 142, and court cites examples in paragraph 51 at page 265. It says in exercise of the powers, 32, 142 guidelines and directions have been issued, large number of cases, and brief reference, a few of them is sufficient. So Kanga with Union of India, Constitution is laid on certain guidelines relating to the Immigration Act, Lakshmikant Khande, guidelines for adoption of minor children, then Sampath Lal, Veeraswamy, etc. Guidelines were laid down having the effect of law requiring rigid compliance. For instance, skipper construction was a real estate issue where you violated the law, breaches of law. And then Advocates in the Court Association, the 9-judge bench, the appointment transfer of judges, which are being rigidly followed matter of appointment, so and so. More recently in Vishaka, elaborate guidelines have been laid down for observance in workplaces relating to sexual harassment of women, so and so. Vishaka, we said, the obligation of this court under Article 32 of the Constitution for the enforcement of these fundamental rights in the absence of a legislation must be viewed along with the role of a judiciary envisaged in the Beijing Statement of Principle for the independence of judiciary in the Asia region. These principles are actually the chief justice of Asia and Pacific Council in Beijing, as those representing the minimum standards necessary to be observed in order to maintain the independent and effective functioning judiciary. The objective judiciary mentioned Beijing Statement or so and so. And after setting out that, then there's an exercise of this kind. But this court is now a well-settled practice with a second firm roots in constitutional jurisprudence. Exercise essentially fill the void in the absence of a suitable legislation to cover the field. So that proposition will always be subject to adjustments, modifications, qualifications, and caveats. So when you draw it so over broadly, and we want to apply it in a particular situation, then court will always ask this question. Is there a legislation which is contemplated? Or it is generally the constitutional obligation to cover a field, to be proactive under the Constitution, and therefore protect fundamental rights. That's where Vishaka comes in. So if you're not proactive and protect women in the workplaces, I just want to digress here for a minute. After Vishaka, there are two petitions are filed, one in Delhi High Court, one in Supreme Court, on guidelines you framed as far as courts are concerned. And guidelines were framed, Mr. Nariman was involved in that, guidelines were framed. And those guidelines were prior to the 2013 Act being enacted. And after the Act came into force, question arose whether these guidelines framed were in consonance with the Act or not. I happened to be heading a committee asked by the court to give a report to the court on that issue. I found there is some dissonance between the guidelines and the Act, particularly because the peculiar nature of a court as a workplace and how to really you adapt those set of principles to court as a workplace. There were some issues. I've given a report. It's still pending with the court for consideration. Why I want to say this? There can be occasions when you move forward, a law comes in, but still there are unattended issues or unexplored dimensions of an issue, which may still call for an understanding and moving further. So therefore, why I want to draw this example is we have a situation on hand where the question is not merely answered by saying there are these kind of recommendations are there. We find that over a period of time that the process of appointment or the persons who are being selected and how they really serve the institution, there are some issues or questions which seem to be emanating. Therefore, on those perceptions, we find that we say there is a mandatory obligation for the state to move into this. That is where I keep encountering some difficulties in saying, yes, this can be done, cannot be done. So, Vineet Narayan may not be a clear and a direct proposition to say that the court will do, because here, except those to equate the IRC recommendations to, Lordship.
The point you are
Yes.
laboring to make is,
Yes, yes.
and which perhaps we may have to get a response from them. We need in Vishaka, paragraph 16 of Vishaka, the court says, in view of the above and in the absence of enacted law to provide for effective enforcement of basic human rights, etc., we are issuing guidelines. In the case of Vineet Saran also, the court of course went ahead and said it must be made a statutory right, an extraordinary
Yes,
to do.
Right.
What you're saying is that in a constitutional provision in particular, when the founding fathers have provided for the mechanism for appointing the chief election commissioner and the election commissioners, there is no vacuum, because the president means the council of ministers. Now, as to whether it is a satisfactory state of affairs, there could be a more ideal state of affairs, a better state of affairs, debatable. Whether that will provide us with a scenario which is similar or identical with Vishaka, no.
I understand.
No.
I understand.
So therefore your argument is really there is no vacuum.
That's right.
In which the court can't really step in.
Right.
Unless we say that we are going to rewrite Article 224(2) in a manner of speech.
That's
Supply and omission, causes omission, which
that's right. That's
the law is that ordinarily we shouldn't be.
You're right. Right.
So we are stepping in on, like you said, idealistic content, aspirations.
That's why I use the word aspiration. I'm using it in a very, very highest level of its content and meaning.
No vacuum. You're basically, there is no vacuum.
Right. And that could be a good aspiration. I don't think one can even debate about it. So that's where the line of demarcations may.
I'll answer that whenever your lordship wants. There's a straight, simple answer.
The moment he completes it, he put it to the side.
See, there is just a slight digression, because you're talking about 1918 expression, etc. That Cards case where eavesdropping, US Supreme Court were called upon to decide whether electronic eavesdropping would be an invasion of your, injunction against searches and seizures. So the Fourth Amendment to the US Constitution said illegal search and seizures are prohibited. So Cards went on to decide eavesdropping is well known, but electronic eavesdropping, is it a search or a seizure? The majority went on to say the Constitution provides persons and not places. That's how they answered that question. Justice Black in his dissent says, no, you can't look at a perceived constitutional silence there and therefore try to give a meaning which the constitution makers did not even contemplate.
That's right.
So a perceived constitutional silence can sometimes be a very debatable area. That's where both Vineet Narayan and Vishaka are not in that category at all. There's a women's right and dignity at workplaces, and it's a matter of immediate action, urgent action. It can't prove delay. And we can't fall back merely on a constitutional reading of Article 21. We need some effective working machinery. Therefore, there is a need to fill up that immediate need. That's how Vishaka came in. I also keep wondering after Vishaka, the court has gone further again on what called exercising its constitutional deliberative engagement only with a view to ensure that fundamental rights get their due. So beyond that, in order that the court enters into that kind of an exercise, there must be to repeat, I'm sorry, I'm repeating, there must be a live connection between the issue and the fundamental. So that's why paragraph 16 takes care of that. I just come back to Raja Rampal for a minute. This is 2007 3 SCC 184. This was Article 105.
Privileges.
Immunities, powers, and privileges for the House of Legislatures. A long debated issue, both and then from Keshav Singh onwards.
House of Commons. Finally, they said it's House of Commons power is there. That's it'll be the same.
So the Constitution bench in this matter kindly turn to. Let us look at page 239, some of the factual background. Page 239. What is the context in which this issue came? 239. The interpretation of Article 105 of the Constitution of India is an issue in this matter. Question is whether in exercise of the powers, privileges, and immunities contained in Article 105, or the Houses of Parliament competent to expel their from are competent to expel their respective members from membership of the House. If such power exists, is it subject to judicial review, and if so, the scope of such judicial review? The unfortunate background in which the opposite questions were written in the allegation. Members of Parliament indulge in unethical and corrupt practice of taking monetary consideration and in relation to the functions of the MPs. A private channel telecasts a program so depicting 10 MPs, House of People, and on the Council of so-and-so, accepting money directly or through a middleman as consideration for raising certain questions, or otherwise espousing certain causes for those offering the lucre. This led to the extensive publicity in the media. Presiding officer of which Parliament instituted inquiry through separate committees. Another private channel telecasts a program alleging improper conduct of another MP so-and-so in relation to the implementation of the Parliament Development Scheme incident, also referred to a committee. Then report of the inquiry concluded the evidence against 10 members of Lok Sabha was incriminating. The plea that the video footage is doctored, morphed, edited, and no merit. There was no valid reason for the committee to doubt the authenticity of the video footage. The allegations of acceptance of money established acts for the acceptance of money, direct connection with the work of the Parliament, and consider such conduct on their part as the unbecoming member of the Parliament and also unethical and calling for strict action. Then, little later, Placitum G, the majority report recorded the deep distress over the acceptance of money and for raising questions now, found it eroded the credibility of Parliament, the institution and pillar of democracy, and recommended expulsion of the 10 members. Then paragraph 5, next page. On the report of the inquiry committee being laid, a motion was adopted the Lok Sabha resolving to expel the 10 members of the membership, accepting the finding as contained in the report of the committee, the conduct of members was unethical, and so and so. On the same day, Lok Sabha Secretary issued an impugn notification notifying the expulsion of the MP, so and so. Then the almost similar process adopted undertaken in Rajya Sabha, matter referred to the Ethics Committee. Then the committee found member had accepted money for tabling questions, and that's how then para 7 report the Ethics Committee was adopted to the Rajya Sabha, and the notification notifying expelled member was issued, and that's how the matter came to the court. Para 9. The two members of the Rajya Sabha have also challenged the constitutional validity of the expulsion article 105 is as follows. Then there is para 10, identical provision 194. Then paragraph 13, their contentions at page 242. The petitioners submit that all the powers, privileges, and immunities are vested in the date of commencement of the Constitution of India in the House of Commons and so on, so have not been inherited by the legislatures in India under Article 105 of the Constitution. Main contention urged that the power and privilege of expulsion is except by the House of Commons as a facet of its power of self-composition, and since such power of self-composition has not been given by the Constitution to Indian legislature, it did not inherit the power to expel its member. The contention is that the expulsion is necessarily punitive in rather than remedial, and such power vested in the House of Commons as a result of the power to punish for contempt. In its capacity as the High Court of Parliament, since the status was not accorded to the Indian legislature, the power to expel could not be claimed to the House of Parliament under Article 1053. It's also their contention the power to expel cannot be asserted to Article 105.3 also for the reason that such an interpretation would come into conflict with the constitutional provision. A grievance has been made about denial of principal naturalization, inquiry proceeding, the gross and patent illegalities, and so on and so forth. Then, just after placitum C, the petitioners submit at page 243 that the constitutional and legal protection accorded to the citizens would become illusory if left to the organ in question to determine the legality of own actions. They further submit it's also a basic principle of law, rule of law permeating every provision of the Constitution. Rather, forming its core essence that the exercise of power by the executive authority must not only be conditioned by the Constitution but also be in accordance with the law. In this context, it is primarily the function of the judiciary alone to ensure the law is observed and there is compliance with the requirement of constitutional provisions. Then paragraph 16, it is a petitioner's contention. House of Parliament had no power of expulsion of sitting a member. They plead the petitioners could not be debarred from membership by an order of the impugn notification pursuant to proceeding consequent upon the media reports in as the substantive and adjective law had been disregarded. The constitutional inhibition placed in the exercise of power of debarment had been defeated. On the case that Indian legislatures cannot claim the power of expulsion members, the contention stated this. Then just look at the legislature has no power to expel members since Parliament has not enacted any law which provides for expulsion of member in a specified circumstance in terms of an enabling power to legislate on the subject as available in Article 105 of the Constitution. Then 3, they're talking about no provision either in the Constitution of India or in the rules of procedure and conduct of business for expulsion of member by adoption of a motion under the Impeachment Act beyond the jurisdiction of Parliament.
Yeah.
Paragraph 36 at page 249. Having given our anxious consideration to the myriad issues that have been raised on both sides of the divide, we have found that the primordial question that need to be addressed by the court can be formulated as under. Does this court within the constitutional scheme have the jurisdiction to decide the content and scope of powers, privileges, and immunities of legislators and members? If the first question is answered in the affirmative, can it be found that the powers and privileges of the legislature in India, in particular with reference to Article 105, include the power of expulsion of the members? In the event of such a power of expulsion being found, does this court have the jurisdiction to interfere in the exercise of said power or privilege conferred in the rules on Parliament and members of committees and so, and if so, the jurisdiction circumscribes certain limits? Then kindly turn over to page 250, paragraph 43.
Yeah.
As can be seen from the language employed in Article 105, Parliament is empowered to define by law the powers, privileges, and immunities of each house and the members and committees in respect of other than those specified in the constitutional provision. Though some part of the arguments advanced before the petitioner did try to refer to certain statutory provisions. For example, provisions contained in sections 8 to 11 of the Representation of People Act is referable to the enabling power given to Parliament in the first part of Article 1053. But for present purposes, we assume that Parliament has not yet exercised the said enabling power, in as much as there is no law enacted till date that can be referred to as cataloguing the powers, privileges, and immunities of each House of Parliament and the members and committees. This consequence leads to the continuity of the life of the second part of Article 1053, in as much as that part of the provision was designed to come to an end as soon as Parliament defined by law its powers, privileges, and immunities. Therefore, powers, privileges, and immunities not having been defined, the question as to what are those powers which are enjoyed by the House of Commons at the commencement of a constitution, that will determine the powers, privileges, and immunities of both houses of the Indian Parliament. Therefore, in a context like 105, we did not prove delay. And if it's a transitional provision, so you don't look back to the House of Commons or whatever available in England. So even in that context, if Parliament has not enacted, what should happen? Was the anxious consideration before the court.
But the court was not invited to, supply any vacuum or that was not the issue there.
I know, but I thought it's important to just to have place it in its position, that's all. So if your comparison with 324(2) and 105, if it is opposite, then there is something to be drawn from this judgment. That's
No, but what conclusion you want us to draw from this authority?
This authority, we want to say, kindly turn to para 166.
Yes.
The court, even after noticing the importance of the need for a parliamentary intervention in this matter, to define the scope of powers, privileges, and immunities, which are as equally important for the purpose of Article 14, Article 19, 1A, and even maybe Article 21 in current point of thinking. Even if in that context, if there is no law, Parliament does not intervene, the court did not think
Court
go
can
far.
direct Parliament to.
That's right. That's right.
Yeah.
Therefore, I'm only drawing a parallel between the importance of that constitutional provision and that constitutional scheme vis-a-vis 324(2). I don't think we can have something on a different pedestal. Both are equally important. Both are equally important. I'm not saying that the higher importance is the lower.
The privileges enjoyed by the members of the House of Commons.
That's right. Therefore,
So
the court felt there is no vacuum.
There is no vacuum.
There's no vacuum.
That is the point. That is the distinction.
So paragraph 166 at page 289. First, it is to be remembered that Article 1053 is itself a constitutional provision, and it is necessary that we must construe the provision in such a way that a conflict with other provisions is avoided.
Yes.
Here are the view that where there is a specific constitutional provision as may have the effect of curtailing this fundamental right, if found applicable. If found applicable, there is no need for a law to be passed in terms of Article 19(6). For example, Article 102 relating to disqualification provides that members who are of unsound mind or on undischarged insolvency declared by competent court are disqualified. These grounds are not mentioned in the Representation of People Act 1921. Though this provision would have the effect of curtailing the rights under Article 19(1)(g), we doubt that it can ever be contended that a specific law made in public interest is required. Similarly, if Article 1053 provides for a power of expulsion, it cannot be said that a specific law in public interest is required. Simply because Parliament is given the power to make law on this subject is no reason to say that a law has to be mandatorily passed when the Constitution itself provides for all the powers of the House of Commons rest until such a law is made. A question may be put to me that, well, there are some existing safeguards available, we borrow it from the House of Commons, therefore there is no vacuum. But here we find that the process of appointment throws some doubt about whether this would be the most ideal way of going about it. Therefore the connect may be little open to question. Your Lordship may put the question to me, I am bound to answer that. But I thought just to draw those conceptual parallels are important.
You have understood.
I only try to draw that. I would take your Lordship through some of the judgments. Before I do that, maybe I think I can continue tomorrow. I wanted to give some information on the Law Commission issues, how many reports. There some information. I'll put it on a small note and give it to your lordships tomorrow. There are more than apart from the percentage of reports of acceptance of reports by the executive government, I'm also trying to look at which report commended itself for acceptance and therefore executive went on to accept, and which report did not commend itself. Therefore, there is always that area where social, political, moral, other considerations. So we have an euthanasia judgment. We have judgments on related fields where court is calling upon executive to frame a law. So those are issues where a moral or an ethical consideration perhaps is hardly a rule. But certain other issues where social consideration, political. So maybe there are areas where the executive may be slow, may be reluctant, may be reticent, may have some reasons. So therefore, unless we have all those effective,
Inputs.
replying back by application of mind to certain reports, then are we not discussing in the abstract? That's what I thought. I can give a little more insights on that. And I'll also come back tomorrow on this information which your lordships provided
So
to me.
it's a little bit of time management. Because tomorrow we got the Jallikattu also.
Yes, yes.
So we'll allow this to spill over.
It is a Jallikattu match.
Jallikattu is also posted tomorrow.
No, I was asked to assist the court, but I have appeared in this matter with some other party.
It's coming up tomorrow.
Yes, yes.
What we can do is.
I don't think I'll take
time
more than
will you-
I
what
don't
is the
think I'll
time
take
which
more
you-
than an hour.
I'll take an hour.
You
So
take
let's
an
say
hour.
both.
So I'll try
to
below or I'll
try
complete
to
it.
compress it even.
Compress it
Compress.
so that we begin our Jallikattu at 2:00 tomorrow.
I understand.
This is what
I understand.
Otherwise, it'll never get going.
We'll need a little while to rejoin because there are lots of questions that have come from your lordship. We need to assist. We'll keep it precise.
I won't take more than 20-25 minutes in my rejoinder. 25 minutes I think.
We'll also need
By one-ish.
I think we
10 minutes
If
for.
they
10 minutes
complete,
for
if the other side completes by 12:15,
12.
then
Don't even make it
by
12:15. Don't give them ideas.
12.
by 12, your lordship has said 12, we will definitely finish before 1.
Yes.
Two of us.
That's enough. That's enough.
20 minutes for Mr. Aniruddha.
Two by whatever you want to do it within that. We'll allow it up to 1:00.
Yes,
Very well.
By 2 we'll start Jallikattu.
Lord, may I point out?
I would also like to conclude because I'm chased by another constitution.
You're right. So this is what we
Needed.
did.
Election Commission may.
Very short.
Election Commission.
And you can supplement it, with written. That's right. Otherwise, it'll never be over.
Please.
With my-
You are supporting him or not? You are supporting?
Election Commission.
Election.
You are supporting?
No, Lords, there is some.
There is no disconnect. There is no dissonance.
No.
But that shows the sign of independence. It's
With my-
election commission
I'm
is not.
hoping the election commission is.
With my lord permission.
Secretary, you are coming tomorrow. Only one question.
Yes, your lordship.
When we are discussing about some process in place
Yes.
in making an appointment on the post of a chief election commission,
Yes.
is any procedure or mechanism in place at the moment which the government ordinarily follow while making an appointment?
Yes.
If it is there, please bring to our notice tomorrow. Or you say, no, we always use our wisdom, the best wisdom available, and then make selection, fair selection.
I don't think I will make that statement.
My lord,
There is no
with due respect to the
No, we
lord,
want before we finally
Obviously, no procedure.
conclude.
No procedure.
So we want, if there is any
Yeah,
mechanism in
Actually,
place
that's a welcome question, and I think it was.
And,
tomorrow.
Lord,
They
but
should
with
actually-
due respect.
because they have made this
Yes,
latest
Lord.
appointment on
Yes,
Friday,
court was making.
It's okay.
Saturday.
Mr. Bhushan, this
They may-
question will
It's
fall
not
upon them
what
to show
process they
what
follow.
is the mechanism they adopt.
What is
No,
the
but this
mechanism they
application
adopted
is still
in this
pending.
particular
The hearing
case?
is going on.
We are not on one.
The mechanism
Then-
adopted.
Then they
day
should.
before yesterday
Then they
was
should await.
fear.
Let's see.
Only
All I
mechanism
can-
adopted day before
Let's-
yesterday was fear.
6 months that vacancy
Yes,
is
my
not
lord.
filled by you.
Please.
And suddenly after we started hearing you,
Yeah.
we see the news flash going that somebody is appointed.
Yes.
We sort of thought immediately what Prashant was saying,
That's,
that there is an interim application filed by us
Yes.
where we want that. So we thought, so we got the idea.
Mere coincidence.
That
These things happen.
that attorney will answer since this question has come, and I don't want to overstep since he is directly in consultation with the government. But all I can say is, my lord's Wikipedia information has given him ideas. They started from the beginning saying that so far as the process is concerned of carrying out the election, so far as the use of the power and 324(1) is concerned, we have no dispute. We are not contesting it. There is no contest on that aspect. That's how they started. The statement made was this: they think it is advisable and desirable that there should be an appointment made to the CEC by an independent agency, which mechanism which is to be. But I'll make my argument. But since the data has come from my lords today, I think they are expending the scope to say they have not questioned. And this was the beginning in the statement itself. They are not questioning the process, integrity, independence of the functioning. So that was the basis of the entire premise based on which the argument started. So therefore, kindly bear this in mind. We'll meet the requirement of the data which my lords have projected to us. We'll meet that requirement, how that should be relevant or not relevant, that we leave it to the final report.
I didn't say.
But they should not move the goalpost to say that now we think there is another notification has come and subject to what information comes from the attorney journals. That should not be. Today, they should not be permitted to say that we are making a new base to say that there's a point exists based on which we can say that there is a malafide or there may be a partisan view which is being taken. That is not, should be the scope of the petition, my respect.
No, all we are saying is, since they made the appointment, it must be fresh in their minds of what process they followed. They could possibly share that fine with
The question has already come from the court.
The question can never be answered.
Balaji, I'll keep it for tomorrow because this has been in somewhere. It's been
When my elder brother asked a question, he also knows there is no answer. He very cleverly answered.
I'm sorry, I've taken a lordship's time.
Grateful.